Welcome back to the Friday Five for July 21st, 2023. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. We're going to look at 5 quick questions from the week in about 5 minutes of time, give you some quick answers and get you along to your weekend. Maybe these are quick questions you've wondered about in the past too. Question number 1 this week: when is a case actually settled? So in this situation, the parties have gone back and forth. They've agreed on a number to settle the case. Actually, one of the parties has even paid money to the other party to settle the case. But when they went in front of the court said, wait a second, this isn't actually settled yet, because they hadn't finalized the settlement terms. They had agreed on a number, but there were still some other terms about what would happen if payments weren't made or other things happened in the future. So the court did not yet mark the case settled. So if you're going to settle a case, you want to make sure you're following the formalities. Especially when you're in front of a judge, you want to make sure you're complying with that judge's rules and regulations as to how you tell the court there's a settlement and how the settlement is evidenced. So some courts will actually have you come in, appear before the judge, tell the judge the terms of the settlement on the record, and the judge can ask each party whether or not they agree or not. That's actually the exception, not the rule, but you need to keep in mind that if you're in front of a judge, you need to follow their regulations, their rules when it comes to how to notify a court that the case is settled. Question 2 this week: what should I do if I'm sued after the statute of limitations has run? So this is a very important question for you to look at when you're a defendant in a lawsuit. You want to first look at, what does the lawsuit say? What's the complaint? What does the notice say about what happened and also when it happened? Because under law, there's what's called a statute of limitations. And that statute of limitations says how long somebody has to sue you if they've breached an agreement. For example, if it's a breach of contract, it's normally 6 years. If they've intentionally created a tort, they've misrepresented something, they've committed fraud, all of these different types of actions have different time periods when the lawsuit has to be filed. And if they haven't filed in time, you need to make sure you raise that in your answer, and also you'll want to consider a motion to dismiss. And this is where it's important to work with an attorney to make sure if you're doing a motion to dismiss, you're doing it the correct way. Question 3, can a court default my company if it doesn't have an attorney? And the simple answer is yes. As we've talked about in prior videos, a company, a business, has to have an attorney represent them. So in this particular case, the client was sued individually and on behalf of the company, and the client actually had an attorney prior in the case who had put in an answer for both the individual and the company, so the company hasn't been defaulted yet. However, as the case goes towards trial and that prior attorney is no longer on the case, the court made it very clear that the individual cannot represent the company as an attorney, so that if the individual hires an attorney, the company also needs an attorney. Now, they can be the same person, presuming that the defendants have a similar stake in the outcome and that they're not adverse to each other, meaning the individual doesn't have claims against the company. You can have one attorney represent both defendants, but you need to make sure you're clear on that so that there's no conflict of interest. Question 4 this week: is my estate liable for a personal guarantee that I sign? Now, this is a very interesting intermix of business and estate planning this week, where the client had a business partner who died, and the business partner was on a bunch of personal guarantees that the company had signed for debt. And the company is having problems, and the bank is saying, wait a second, so-and-so died, what are we going to do next? And the person who called was concerned because he can't afford to take over the full amount of the loan that they personally guaranteed. Actually, his partner had a little more money than he did. So if you're confronted with this situation, the first place to look is the guarantee itself. You want to look at the paperwork. So depending upon what the paperwork says, that personal guarantee either has to be paid by the estate or it doesn't have to be paid by the estate. And what we're looking for is whether or not the guarantee is divisible between the two parties or whether it's held liable against both parties, meaning that one party can be liable for the whole debt that's being guaranteed. So while I'd love to give you a simple answer to this, the actual answer is it's going to depend on your paperwork and what the personal guarantee note says. And question 5, it's an oldie but a goodie. Should I name a backup guardian and trustee in my will? The answer I always give is yes, because you never know what's going to happen with the person you choose as a guardian or trustee to manage money or take care of your children under the age of 18. If something happens to them before you die, or for some reason they're unable to help out your children as a guardian or a trustee, we want to make sure we have a backup who's appointed. So your document's going to usually say person A is the primary guardian, and then person B, and then C, and even possibly D in case A, B, and C are unable to serve. So we want to make sure we have at least one or two successors named in the document, just in case something happens with the primary person you're choosing, because you never know in this world what might happen. So there you go. There's our 5 questions for the week in about 5 minutes. If you liked the video, please hit the like or thumbs up button. You can subscribe to future episodes on YouTube. If you'd like to submit a future question for a future episode, there'll be a link in the comments. If you need more information or to set up a legal strategy session, you can go to 𝙃𝙀𝙍𝙀.com. On the homepage is a red button where you can get on my calendar and we can set up a 15 or 20 minute call to see how we can help and give you a plan for going forward. And if nothing else, I hope you have a wonderful weekend and I will see you next week.